you first have to go to the people. And that ideally was the genesis. Now it became one of the terminology that is being espoused all over. You cannot, there are certain bare minimums on the Constitution. In order for you to make changes to the Constitution, you cannot just, as Parliament, go at it.
In the courts, there's a lot of technicalities, a lot of things that people maybe don't understand. Is it important? So I just want you to drop down in the comments and say, you know, like maybe what you think or what you feel about this whole process. There was a whole, you know, like 5-hour session on TV, 5.5-hour to 6-hour session on TV on this particular ruling. And this, of course, this is the culmination of all arguments that had been presented, you know, like before. So it was a very interesting listen. So I'd like to, you know, like get your views on this. And now here we know that the court ruled on 7 issues that emerged from the previous Court of Appeal decision that had effectively paused the Building Bridges Initiative referendum process. Now the issues on hand included the applicability of the basic structure doctrine, which we shall be discussing shortly. Then also they ruled on whether a president can initiate a popular initiative constitutional amendment. They also touched on the process by which new parliamentary constituencies can be added. The court rulings further included verdicts on whether civil proceedings can be instituted against a sitting president, the minimum thresholds for public participation, and also the number of IEBC commissioners required to constitute a quorum, which can conduct their functions. Now, this was among a number of other issues, so we want to stay focused today because quite a number of things that we're going to be talking about. And Slay here says, like Mika said, it affects us who live in diaspora, so I think it's important to be in the know of what's going on back home. But at first, I want to come to OneMic, you know, kwanza usalimie wasikilizaji. And OneMic has been doing some reading on the basic structure doctrine. This was, you know, like an aspect that was very confusing to a lot of people who are maybe hearing it for the first time. Now, the majority ruled that the basic structure doctrine is not applicable in Kenya. So, Uno, please tell us what the basic structure doctrine is about and its origin so that people can understand what the meaning of the basic structure doctrine not being applicable to the Kenyan Constitution is. Uno, twende kazi.
So the basic, by the way, that thing really confused the hell out of me. Because I was trying to understand when they're talking about the basic structure doctrine, and this was being argued actually when the lawyers themselves were actually presenting their case in the hearing.
Yeah.
And it confused the hell out of me because they're like, okay, basic structure doctrine, and they were always mentioning India.
Okay.
So now in India, apparently, so basic structure doctrine, in simple terms, is that there are certain things in the Constitution that cannot just be changed. They are more like permanent.
Yeah.
Ni kama umepata gari iko na frame yake.
Yeah.
All you can do is just add.
Yeah.
But in order
or the foundation of a house.
The foundation of a house.
Yeah.
You can't just go there and bomoa all willy-nilly.
Yeah.
And this results from a case in Indian that was in India in 1973.
Mm-hmm.
And I think it was about a lady who there was an property, and the judgment was 7-6, and it stated, well, in summary, that Parliament cannot just go ahead and make amendments all willy-nilly. You can't just go there and say, you know what, nimekuta gari, you know, foundation, then you can adjust it all you want, however you want. There has to be, there's a certain bare minimum,
mm-hmm.
and the bare minimum is the Constitution itself. The bare minimum is you cannot just make changes as Parliament, because then that would give Parliament all the power, and they can just misuse it, and they can just do madhogodhanyo to it. So the idea is, in order for you to make changes, you have to first go to the people. You first have to go to the people. And that ideally was the genesis. Now, it became one of the terminology that is being espoused all over. You cannot, there are certain bare minimums on the Constitution. In order for you to make changes to the Constitution, you cannot just, as Parliament, go at it. So watu lazima kwanza wakuja wafanye kazi.
So in short, like there are some eternity or entrenched clauses that are unamendable in the Constitution.
Yes.
But it's important to note that this ruling say that doctrine, which is a judicial innovation.
Yes.
It's not part of the Constitution. It's a judicial innovation.
It's not, yes.
But the ruling that came from the Supreme Court said that is not applicable in Kenya.
Yes.
So everything is game.
Yes.
Anything can be amended.
Yes.
According to the ruling.
According to the ruling that was read by Justice Kome.
Okay.
Yes.
But now on this ruling, there was a dissent by Justice Mohammed Ibrahim, and I think on the document that we have, if you could just bring that dissent by Justice Mohammed Ibrahim, which was on number 1, on the number 1 ruling, if you could just scroll down for a little bit so that our viewers can get to see this, to get the meat and bones of what's happening. So let's go down. So you see, okay, on the reasons for the first findings, that second paragraph. So forget about the first paragraph. Now the second right there, where it says, there you go, very good. So you see there, it says dissenting. Uno, just read for us what Justice Ibrahim said.
Yeah, it says dissenting Ibrahim SJs agreed with the High Court and majority of the Court of Appeal that the basic structure doctrine is applicable in Kenya. He agreed with the High Court that fundamental features of the Constitution, which are to be identified on a case-by-case basis by the courts, could only be amended by the people in exercise of their primary constituent power. He further found that genuine exercise of primary constituent power can be identified through the 4 sequential steps prescribed by the High Court.
Okay, thank you so much. So you can take it down for now. But we just wanted you to see that because this was now a dissent. This was a dissent of the majority. So the majority has already decided that basic doctrine structure does not apply in Kenya. And this brings, and for those maybe who also want to understand better that basic doctrine structure, imagine a house. There's certain parts like the foundation and the pillars that cannot be taken down. If you take them down, it's going to destroy the whole house, or it's going to permanently alter the character of the house. So what the dissenters are saying, what the dissenter is saying, Justice Ibrahim, is that there are certain clauses in the Constitution, if amended, it's going to destroy the whole character of the Constitution.
Just to provide kidogo context, when people are rebuilding a house, the structure itself, you can, there's load-bearing walls.
Yeah.
You cannot move.
You cannot move them.
No.
Yeah.
Not unless if Omosh is an architect or whatever, he comes in and lays down the law or whatever. But the gist is
you would have to change certain things, like put in some some cross beams.
And you'd actually have to even get some people come in, an engineer, whatever, the city, state, whoever is concerned to come in, authorize and see, and somebody whose certification or his license would be at risk in case anything happens. So you can't just change it for her.
Okay. All right, good. And this ruling has actually, it brings in some interesting precedent, and we're going to be letting also Mika, give us his 2 cents on this, and Omoshe in the studio, but it brings an interesting precedent in the fact that the majority rule that these amendment procedures have already been provided for in the Constitution. So the Constitution does not need, a foreign doctrine, because sometimes these foreign doctrines are used to fill in gaps of ideas or issues that might be missing in the Constitution. So this was a very interesting ruling because they went against that international precedent, which is very common, sometimes in Kenyan courts. Like in this case, they were bringing that Indian case. But the majority say that this ruling, this constitution has enough provisions, on what is amendable and what is non-amendable, and we do not need an external doctrine. Omoshfire.
You're looking for me to add to the external doctrine?
I'm looking for you to chime in on the conversation because umeingia, umechelewa, and and you're ruining the flow of the conversation.
It's April Fool's, bwana.
Okay, sawa. Let's go to Mika. Mika.
This guy over here.
See your kitu ishanga midday.
Let's go to Mika.
April Fool's is a whole day.
Who said so? Why are you fooling us now?
Oh, he's trying to fool us, Satan.
Okay, Mungu watu.
Ali.
Yeah.
Wacha turudi kwako huko vitu serious. You were saying?
No,
No,
we're talking about the basic structure doctrine, and this is one of those aspects that people had, like some difficulty in understanding. I
think it's the ruling. It's just the overall ruling, like the wording that they have for the ruling, because when you look at I think I saw like three judges who ruled on it. But anyway, the way the wording is, it's it's that legalese that is used that throws people off, and we just need things broken down more simply to tell us, okay, like we did here.
No,
foundation,
it's just
this, that, the other, without this, and the law says that you cannot change this without actually having an amendment and or changing this particular thing in the constitution. That's the only way that you can then now come in and start breaking up certain things. And I think that's the problem with Kenya, with a lot of the laws that we have. Go ahead, Mika.
But then there's like the example over here where the constitution in this country cannot be changed. Even if it's amended, it still has to retain the basic structure of it. Like, regardless of what you amend on that constitution, tuseme kama ile ama jambo gani upenda kutumia for them
second amendment.
Second amendment, right? Yeah. It can never be just scrapped away and thrown away. There will be amendments to it based on how we evolve as time comes, but there will never be a day where they say, okay, we're going to scrap this off, nobody can bear up. It can never happen. So I think it's the same thing with just Kenya. There are those basic aspects of the constitution that cannot be amended. They're supposed to be like that. You can twist them, you can put wording around them, but there's that basic structure that's supposed to guide how the constitution of the country is written. And I think most judges felt like the BBI was touching too much into that structure of the amendment. It was like they were ripping away that law and trying to switch it away. If we follow how the Indian example explains it.
Now, if we if we look at this first ruling carefully, this was actually a pro BBI ruling, and I know maybe some people may not like hearing this. Because and here's the confusing part. That basic structure doctrine, the ruling was that it is not applicable, meaning the Kenyan constitution does not have a basic structure. It's not applicable. It cannot be used.
Gotcha.
Justice Muhammad Ibrahim dissented and gave his reasoning, because the reasoning of which came from the High Court, because this went through the High Court first, then was upheld by the Court of Appeal. But this ruling here kind of overturns that, meaning that the High Court felt that to alter the basic structure, you need to go through a constituent assembly process, like the process we went through before the the 2010 promulgation was done. But now the Supreme Court is saying no, there's no there's no requirement for a constituent assembly. This can be a basic structure doctrine doesn't apply, because now the argument comes also which part is the basic structure and which is not.